I hope my PowerPoint presentation is visible. Yes. All right. So we have to start an important topic today, and the topic is bail. Please understand here that the term bail has not been defined in Criminal Procedure Code. The Criminal Procedure Code, though has not defined the concept of bail, has used this term so many times, has referred and in fact classified offences as bailable and non-bailable offences. But it does not tell us what is the meaning of this concept. So if we pick up various definitions given in various dictionaries or, or in judicial pronouncements, we will find that the concept of bail is invoked in the case where accused is arrested pending trial. So this concept of bail, whatever it is, this concept operates before conviction happens or before the order of acquittal happens. So from the time the offense has been committed till the time of determination of guilt, this concept of bail operates. That's the time limit. ये कब होगा? Again, what does this concept entail? This concept entails that accused, if he is arrested, he is given in custody to someone else. So basically, the concept of bail involves transfer of custody. What happens when an accused commits a crime? So whenever an offense is committed, according to the classification of offense, if arrest happens, he is taken, his liberty is taken by the state. Yes. And now he is no longer a free person. The concept of bail interposes here and says, let the state who has taken this person in custody release this person to the custody of another. So what the state is doing in the concept of bail is, it is transferring the custody of an accused from its own hands to the hands of a private person who undertakes, this private person undertakes that whenever the state requires this particular man at the time of trial or for any other purpose, then I undertake to produce him before the proper court which requires him. So bail involves transfer of custody of the accused from state to that of the surety. Now, why I am stressing on the word transfer of custody? Because please keep in mind that when a person is is released on bail, he is not a free person in technical sense. Yes, he is free, he can move, but that movement can be conditioned. Am I clear? And till the final decision of the court comes, so once he's accused, till the final decision comes, if he is enlarged on bail, he's no longer free person, as in he does not have all the rights. Now, this basically is the concept behind bail, and there are various competing interests which have led to the evolution of this concept of bail as we have it today. There are some value-based concepts and there are certain pragmatic reasons which have led to the evolution of this concept of bail. First, let me discuss the value-based concerns. See, one of the basic premises of our criminal law is presumption of innocence of the accused. So if the accused is presumed to be innocent until proven guilty, why should he suffer the sentence? Why should he be arrested pending trial till that guilt is adjudicated by the authorities? So the concept of bail is in consonance with his presumption of innocence. However, there is also a concern that the investigating agency has the right to interrogate, has the right to investigate the matter for which the presence of accused is required. So therefore, we say that right of arrest is there, but this right of arrest has to be made compatible with the presumption of innocence. And bail is one mechanism which tries to synthesize both these competing interests. Secondly, uh, yes, it is a part of liberty of the individual that it should not be unnecessarily restrained. So he has his liberty, whereas there is also concern by the society that criminals should not be free. So the concern of the society to be free of crime is also competing interest, which says accused people or suspected people should be behind the bars, they should be arrested. So again, a balance is drawn that for some time there can be arrest, but when conditions are fine, then under certain conditions, the person, accused person or suspected person can be released pending trial. Then there are certain pragmatic concerns which drive or which lay emphasis on bail. The first reason why this concept of bail got prominence was that there were shabby conditions in jail, due to which a lot of diseases were rampant, particularly in jails. If you see the history of 16th or the 17th century, you will find that the word jail and the picture of jail was very shabby. So all the kind of infections, influenza, they started there. In fact, that is one of the reasons now today that COVID, because COVID has spread, that premature release on bail has been ordered. जहाँ पे bail नहीं भी मिला, because it is a COVID situation, the courts have been very liberal in granting that. So yes, disease was one condition. And now see, if the accused is in the custody of state and there is disease, it is obviously the duty of the state to provide him medical aid. Not only medical aid, it is also the duty of the state to provide him with food. At least basic necessities the state has to provide, not lavish necessities, but basic necessities have to be provided for survival in jail. So that puts unnecessary financial burden on state. Also, jails, they require continuous surveillance, they require manpower, they require infrastructure, which is not or which may not be available with state. In India, we have the peculiar problem of high crime rate versus low conviction rate, which means that there is a burden on the existing infrastructure, which leads to overcrowding of jails. Now, overcrowding of jails is itself a problem which can be solved through the mechanism of bail. Then there are certain human rights of the accused, again value-based concerns that he has a right of family which should not be necessarily interfered with, and other interests. So balance of value-based concerns and pragmatic concerns has over a period of time led to the evolution of the concept which we call as bail. Some people have criticized the concept of bail and called it as commercialization of justice, because it requires, when a person is released on bail, it is required that he give a monetary surety. It can be someone else can stand a surety for him, or he has to execute a personal bond. Let us see how far as the claim of commercialization of justice withstands with respect to Indian conditions. I'll discuss that in a while. But broadly, these are the competing interests. These are the main reasons why the concept of bail has been given. I forgot to mention here, this is section 2A. Offenses have been classified as bailable offenses and non-bailable offenses. There is no criteria which is mentioned here as to when. They say, look at Schedule 1. Schedule 1 will tell you whether an offense is bailable or non-bailable. But they have not given the reason why a particular offense has been made bailable or non-bailable. Only when we see part 2 of Schedule 1, which says that if it is any other offense and it has not been provided whether it is bailable or non-bailable, then offenses which are punishable with imprisonment up to 3 years are bailable, but which are less than 3 years are bailable, but which are 3 years or more than 3 years are made non-bailable. So basically, looking at the punishment, yes, punishment is one of the criterias which have been taken into account while classifying offences as bailable or non-bailable. But this has been deviated in IPC in many places. There may be offences which have very less punishment, but they are made non-bailable, and vice versa. There are exceptions to that particular rule. Then comes the question, who can grant the bail? Depending upon what is the nature of the bail being asked for, bail can be granted both by the magistrate as well as by the police. However, you would find that police has exercised this power in very rare circumstances. There is an article which I'll forward to you. It's written by a man who has talked about, who's done a study basically on the power of police to grant bail. I'll just name that article. Very interesting one. But yes, it can be granted both by police as well as magistrate. Anurag Deep is the person who has written this article. I'll forward it to you, who talks about the power of police. But yes, it can be done in many cases. How is a bail granted? A bail is basically granted by the court or the police officer on a bond. Now, what is this bond? This bond is mentioned in section 441, which is read along with form number 45 of schedule 2. So basically, the person who is standing as a surety, he has to execute a bond that I will produce this person at the time of the trial. I undertake. And if I cannot, then you can forfeit my property. Or it can be a personal bond that I undertake to be present. And if I do not, then you can forfeit my property of this much sum. So that's basically a bond. So it means that there is money involved in the concept of bail. Now, what if, and who decides this money? This money, this quantum of bond is decided by the court or the person, the police officer who is granting bail. Now, what if the money which is demanded by the from the person by the court is too much? Doesn't that affect his fundamental right to equality then? Because it should have been per the offense, that if I have done the offense or if a rich man has done the offense, we should be entitled to bail under same circumstances, whether it is A doing an offense or whether it is Ambani doing an offense. Both should be treated similarly. लेकिन ए ने ऑफेंस किया है तो उसको कोर्ट में जाना पड़ेगा, बेल देना पड़ेगा. लेकिन अंबानी, उसके पास पूरी बैटरी ऑफ लॉयर्स है, वो उससे 1 करोड़ रुपया भी मांग लेगा तो उसके लिए कुछ नहीं है. लेकिन अगर मुझसे 1 करोड़ रुपया मांग लिया जाए एक ऑफेंस में, फॉर मी इट इज टू मच. Does it mean that the concept of bail is tilted towards pro-rich? Prima facie, yes. And this problem of monetary consideration has come before the Supreme Court in one of the infamous cases of Moti Ram versus State of Madhya Pradesh. In this case, what happened was that basically there was a mason, मिस्त्री जो काम करते हैं, आपके जो डेली लेबरर्स हैं, migrant laborers जो काम करते हैं, he was asked to submit a bail bond of rupees 10,000. See, the year of a decision is 1978. The offense happened somewhere in 1970s. When he asked for bail, that was 1976. And when the decision came out in 1978, जिस टाइम सैलरी एक गवर्नमेंट ऑफिसर की 100 रुपीज थी, this man was asked to give 10,000 rupees as the bail bond. Now it was too much for him to pay. He could not have. उसके पास तो नहीं था. Neither was he friends with any rich man. आप श्योरिटी किसी को भी ला सकते हो, but you have to be friends with those people. And why would a rich be friends with a mason and then stand a surety for him? So his bail he was not granted bail. And now when the bail was granted by the chief judicial magistrate, the amount was so onerous. So he comes for the modification of his bail bond. And now the matter has reached, so from 10,000, it was reduced by the High Court to, I guess, 3,000 or 5,000. Again, he did not have that capacity to pay. And now he has come before the Supreme Court. And Supreme Court says this is denial of principle of equality. And second thing, when he produced a surety here, okay, for whatever amount, the court did not consider him as, the court rejected him as surety because he was not residing in the same state. His property was situated in a different state. Supreme Court said this is denial of justice, this is denial of equality. Whether sureties have to be insisted or not, that depends upon the discretion of the judge. They could have released him on a personal bond also. And what money has to be demanded, that has to depend upon facts and circumstance of each case, and the court has to take in mind the financial background of the accused. It cannot be unnecessarily high so as to amount denial of the right of bail. A condition cannot be onerous so as to amount denial, virtually it's not available, so that cannot be done. And again, the court said that merely because a surety is not residing within that state, that cannot be a condition that you should produce from that state only. The court said, then what will happen to a Tamilian who has visited Punjab and vice versa, and he has been caught up in some offense? He will never get bail. What if an Adivasi comes to mainland India and he commits something? He will never get bail in such cases. So the court was against such provincial allergies, which was said, and said you cannot insist on language, you cannot insist on residence. These are not the criteria which should be taken while a surety is to be accepted or rejected. Based on this discussion that we have, that when bail bonds are to be executed, onerous conditions are not to be put. One of the very recent phenomena in our country has been of putting as a bail condition certain amount of money as a contribution towards the PM Cares Fund. Probably, or some of these judges are eyeing their elevations, or they are eyeing certain promotions. Here you have a conflict of two different high courts in our country. On one hand is the Kerala High Court and its decision of 22nd April in the case of Chinna Rao, and on the other hand you have Justice Anubha Rawat Chaudhary of the Jharkhand High Court in 3 cases, and I have just picked up one, Imran Khan versus State of Jharkhand. In the case of Chinna Rao, let me discuss these two different approaches. In Chinna Rao's case, this man was arrested and he was to furnish bail. His was a statutory bail under 167 clause 2. But the Sessions Court said that bail will be granted only if you deposit rupees 25,000 in the PM Care Fund as a so as to fight this corona thing. Now, this man challenged this particular condition of the bail, and the High Court quashed that order of the Sessions Court with respect to this deposit of this amount. High Court paid reliance on Supreme Court's decision in Motiram versus State of Madhya Pradesh and said that amount of bail cannot be unjust, improper, so as to amount a denial of the right of the bail. So the order was quashed that security deposit cannot be asked for the grant of bail. Whereas the Jharkhand High Court has made it mandatory that unless and until you deposit 5,000 in the PM Care Fund and you download Arogya Setu app, you will not be released from, you will not be released on bail, and the bail order has been made conditional. So the officer to whom you will present, you will show the proof, only then you will be admitted to bail. Now, this is a contentious question whether there should be this amount or not. According to me, bail cannot be made conditional on the deposit of a particular sum. हम श्योरिटी ले सकते हैं एज पर सीआरपीसी. व्हाट यू कैन टेक इज श्योरिटी. श्योरिटी भी ये कि वो लेके आएगा, एज लॉन्ग एज ही इज कमिंग, द अमाउंट इज नॉट फोरफिटेड, वो सिर्फ एक बॉन्ड है. बॉन्ड का क्या मतलब होता है? दैट इन केस ऑफ ब्रीच आई एम लायबल टू पे. इट इज नॉट पेमेंट अप फ्रंट कि 50,000 आप रख लीजिए फिर मैं लेके आऊंगा. इट इज नॉट पेमेंट अप फ्रंट. इट इज ओनली इफ ही डज नॉट कम देन आई एम लायबल टू पे 50,000 और वट एवर इज द बेल अमाउंट मनी. लेकिन यहाँ पे क्या है, आप मनी डिपॉजिट करिए पहले and then we will give you bail. According to me, this approach of Jharkhand High Court and even Allahabad High Court, which also has made certain conditions, preconditions as to deposit of certain money in PM Care Fund as a prerequisite for grant of bail, according to me, they are unconstitutional and also against the statute, that they cannot do that. There is no power in CRPC or under your constitution to demand a sum of money in a private fund as a prior condition to being released on bail. That's my discussion, because the concept of bail is intrinsically linked to the money. So I thought of discussing this here. Otherwise,
मैम फिर खान में हुआ क्या था फिर?
just 1 second. Yes, Jhalak, repeat your question.
मैम फिर इमरान खान में हुआ क्या था?
उसने पैसे डिपॉजिट किए. झारखंड हाईकोर्ट का एक और केस है, ये इमरान खान वाला 16th अप्रैल का डिसीजन है, वेयर वन मैन, ही वाज आल्सो आस्क्ड टू पे 5,000. ही डिड नॉट हैव द मनी and he made a representation before the court कि I do not have money so as to deposit in PM care fund. उसको नहीं बोला, लेकिन उसको सिर्फ आरोग्य सेतु के लिए बोला. My only condition is that even if you have the ability to pay 5,000 or let's say 5 lakh or 5 crore, still it cannot be made a condition for bail. Because the concept is only of surety. This matter did not go before the Supreme Court. Akshita, no, this matter has not gone before Supreme Court.
मैम 373 में वो कुछ कर सकता है क्या इस चीज का? क्योंकि
373 में कैसे करेगा बच्चे?
मैम आपने बोला था ना उसमें प्रिवेंटिव एक्शंस होते हैं, तो उसमें भी 117 या आई गेस 122 जो भी सेक्शन
पढ़ो
था उसमें
373 क्या? 373 पढ़ो. 373 बच्चे अपील की बात कर रहा है, श्योरिटी की बात कर रहा है वो. यहाँ पे हम 117 या 121 का बात नहीं कर रहे हैं, हम बेल का बात कर रहे हैं. इफ देयर इज अ रिफ्यूजल ऑफ बेल बाय वन कोर्ट, देन यू कैन गो टू द अदर कोर्ट. बेल कंडीशंस अगर आपके ऊपर इंपोज कर लिए, दे कैन बी चैलेंज्ड. आई होप आई एम क्लियर विद दैट. इसका कोई लेना देना नहीं है अपील से. हेलो
मैम इसलिए मैं कंफ्यूज हो गई क्योंकि वो वाले सेक्शंस में जब होता है तो एक अग्रीमेंट होता है, उसमें भी बॉन्ड होता है, उसमें भी श्योरिटी वाली चीज आती है. तो मुझे लगा मे बी बेल वाली चीज का वैसे इंटरप्रेट करके वो 373 में
373 नहीं, वहां नहीं जाएगा. Kumar Satyam, बच्चे, what I'm trying to highlight here through these recent cases is that surety is a different concept and demanding of money upfront is a different concept. Are you understanding me? And bail, not anticipatory bail, bail, which is also part of your fundamental rights, cannot be dependent upon the economic condition of an individual. Please remember this. इसीलिए कॉन्सेप्ट श्योरिटी है, एंड जहां पे पर्सन इज अनेबल टू पे, देन ही इज गिवन एन ऑप्शन ऑफ एग्जीक्यूटिंग अ पर्सनल बॉन्ड ऑल्सो. ठीक है? सो अकॉर्डिंग टू मी इट वायलेट्स दोस प्रिंसिपल्स, देयरफॉर इट कैन नॉट बी डन.
मैम तो चिन्ना राव को बेल मिल गई ना?
इसको
चिन्ना राव वाला जो केस था,
चिन्ना राव को बेल मिल गया. हाँ, बिना पीएम केयर में डिपॉजिट किया उसको बेल मिल गया. उसका बेल ऑर्डर मॉडिफाई कर दिया हाई कोर्ट ने. ठीक है? Someone else has asked me a question. I guess it's Satyam. Payment to PM Cares Fund won't serve the purpose of bail. बच्चे, payment to any fund will not serve the purpose of bail, because bail का purpose क्या है? To ensure that the accused comes to the trial. Now, if I deposit the money in the PM Care Fund, how does PM Care Fund ensure that I'm coming for the trial? Surety किस लिए? To ensure that I'm answerable for the trial. PM Care Fund is not going to return or refund my money if I come to the trial. Are you understanding that point? तो जब श्योरिटी का कॉन्सेप्ट है, श्योरिटी का मतलब ये है कि अगर इफ देयर इज अ फेलियर ऑफ पेमेंट देन आई एम लायबल टू पे. कंटिंजेंट लायबिलिटी, यहां पे इमीडिएट लायबिलिटी टू पे है, which cannot be done. You cannot demand money for a person to be released on bail. If money is demand to be released on bail, कि इतना डिपॉजिट करिए कोर्ट में और फिर आपको बेल मिलेगा, इतना अमाउंट आप डिपॉजिट करके जाइए, then that's a violation. Or you are taking cash for grant of bail, which is not allowed. I hope I'm clear with that.
मैम
Yes.
मैम अगर पूरे लॉ में सीआरपीसी में यही मेंशन्ड है कि श्योरिटी लगाना है ना कि पेमेंट करना है, तो फिर व्हाट वाज द रीजनिंग ऑफ झारखंड हाई कोर्ट एंड इमरान खान?
No reasoning. बेल कंडीशन डिस्क्रिशन है उनका, कुछ भी कंडीशन लगा सकते हैं. They've used their discretionary power.
हाई कोर्ट ने इश्यूज डिस्कस करते वक्त लाइक दे डिडंट गिव एनी रीजन एज टू व्हाट वाज द हाउ वाज द लॉ
No,
प्रेसिडेंटेड?
no, 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 no. बहुत सारे कंडीशंस में जैसे आपका चंद्रशेखर का एक केस है विच आई विल टेक अप टुमारो. उसके केस में एक कंडीशन उन्होंने इम्पोज किया कि आप कोई भी स्पीच नहीं देंगे विच इज पॉलिटिकली इन्फ्लेमेटरी. आप दिल्ली से बाहर चले जाएंगे इलेक्शंस तक. कैन दी हाई कोर्ट इम्पोज सच कंडीशंस व्हाइल ग्रांटिंग बेल? We will discuss that when I'm discussing bail conditions in detail. Abhi to I had just discussed monetary impact because this decision relied on Motiram. Therefore, I thought fit to discuss. But this topic will be continued कि कैसी nature of bail conditions जो है court impose कर सकता है basically non-bailable offences में. ठीक है? Yes.
यस मैम.
Mangalam Pandey has asked me a question. Any sort of payment for providing bail? Yes. हमारे यहाँ एमपी हाई कोर्ट में तो ट्रीज प्लांट करने को बोल देते हैं. ऋत्विक, आई विल टेक अप ऑल दोस क्वेश्चंस. वेदर कम्युनिटी सेंटेंसिंग कैन बी ऑर्डर्ड, ये जो ट्रीज प्लांट करना है या फिर कम्युनिटी सर्विसिंग करना है, इनका क्या वैलिडिटी है? वी विल डिस्कस ऑल दिस once I'm doing non-bailable offenses. I'll just resume my presentation now. Okay, just give me 1 second. So let's discuss now when bail is available. Bail basically under CRPC can be discussed under 4 headings. 1, as a matter of right, where there is no discretion available to the court. और वो कोई कंडीशन भी इम्पोज नहीं कर सकता है. इट हैज टू गिव बेल. आई टेक अप योर क्वेश्चंस एट द एंड. आई कैन नॉट सी योर स्क्रीन्स एज ऑफ नाउ. Second is bail in those cases where it is the discretion of the court. Third, irrespective of the nature of the offense, the accused is entitled to bail because there is a default of the investigating agency. Default bail, something which we have already discussed under section 167 clause 2. Fourth and the last category, bail is granted in anticipation of the arrest. So anticipatory bail. Now whether anticipatory bail is actually a bail or not, that is a matter which we will discuss in detail. First, let me discuss the first one, as a matter of right. There are basically 3 cases where bail can be granted as a matter of right. I'm referring to 3 sections now. Section 436, Section 436A, and Section 437, Clause 6 and Clause 7. Bail as a matter of right. In offenses which are other than non-bailable offenses, meaning thereby which are bailable offenses. So wherever accused is arrested in a bailable offense or he is brought before the court, arrest nahi hua hai, court mein uski peshgi kar di seedha, then if the accused is prepared to give the bail, he is ready to give the bail, then the court has no discretion at all to find out anything. The court has a mandate to release that person on bail. He is ready. He is accused only of bailable offense. the court or the police officer has to release him on bail. No conditions whatsoever can be imposed here while granting bail. ना तो उसको ये बोल सकते हैं कि you deposit your passport, ना उसको यहाँ पे ये बोल सकते हैं you deposit 5,000 to corona relief, or you download this app, or you do this, or you do that. No conditions at all can be imposed while granting bail under 436. It is the right of the accused to get bail. However, again, this right is when he is ready to give the bail, when he is prepared to give the bail. So this bail can be given both on personal security, on his personal security, or there is a surety. He can produce that. However, problem comes with respect to indigent persons, people who are poor. They may not be prepared to give the bail because they do not have sufficient means. So for them, there is a provision made under section 436. The provision is that if the court thinks, if the person, the police officer or the court thinks that the person is indigent person, then instead of stressing on amount ki bond execute kariye, you can release him on his personal security, personal bond pay. He undertakes personal responsibility, then he can be released on bail. Second important thing here with respect to indigent persons is provided in explanation to section 436 clause 1. There are certain persons who are deemed to be indigent persons. अब पुलिस ऑफिसर को कैसे पता चलेगा कि इंडिजेंट है या नहीं है? If for continuously 7 days, that within a week after his arrest, he has not given bail, then it is presumed that that man is an indigent man, and then he is entitled to be given bail on his personal bond. Then you cannot stress on surety. This is as a matter of right. However, please remember this is confined only to bailable offenses. And second thing, it is available only where the accused is prepared. Where accused is not prepared, he wants to be in jail, let him be in jail. Then you cannot do anything. And one important thing that you have to remember here is that when a person is accused of a bailable offense, he is arrested, he has to be released on bail, and the victim or the complainant has no right here to interfere with this right of the accused. They cannot do anything here because this is right. Otherwise, that would amount to rewording of section 436. In one of the cases, a very interesting case, Rasik Lal versus Kishore Wadhwani, 2009. There was an interview. The facts of this case was that there was an interview which was given on Star TV, and the complainant, on the basis of that interview, filed a case of defamation, 499 and 500 of IPC. And then that's a bailable offense. 499 and 500 are bailable offenses. The accused was arrested, and subsequently, as soon as he went to the police, he was granted bail. Now, what happened here was when bail was granted, the complainant has challenged the grant of bail in this particular case, saying that I was not heard before bail was granted to this particular man. So, जैसे ही वो process issue, it is a complaint case. जैसे ही वो complaint accused under 202, he is going before the court. He simultaneously files an application under 436, which is accepted, and he is granted bail. But he is not. The complainant is not heard here. So the complainant has now said that my principle of natural justice has been violated, and I should have been heard. So High Court agrees with this contention of the accused, of the complainant, and cancels the bail which had been granted to the accused person. Now the accused has come in appeal before Supreme Court, and Supreme Court said this was illegal, what was done by the High Court. There cannot be any cancellation of bail on the ground that complainant was not heard. In fact, a complainant does not have a right to be heard before a person accused of a bailable offense is released on bail by the police officer or the court. Am I clear? So no right of victim here. This is with respect to 436. The second thing here is that irrespective of what is the nature of the offense, whether it is a bailable offense or it is a non-bailable offense, there are prisoners, under trial prisoners, who are entitled to bail as a matter of right after serving a specified period. This section has been added after the case of Husainara Khatun. Husainara Khatun versus Home Secretary. This was added by amendment of third. This is 2005 amendment. Why this was added here was because I I guess this amendment was happened in 2000. Okay, this is 2005 amendment. Why this section was added was basically to give effect to Husainara Khatun's judgment. In Husainara Khatun, this was brought before the notice of the High Court. This was brought to the notice of the Supreme Court that a lot many under trial prisoners are languishing in jails, though they have though they have finished the maximum of the sentences which were prescribed by law. So let's say an offense which was punishable only with 2 years. This person has been in jail for 7 years. Court said this is violation of his Article 21. This is violation even of speedy trial. His liberty has been curtailed beyond what is prescribed by law. Cannot be done. This is illegal. So in that case, court ordered release of all those persons who had served the maximum sentence prescribed by the law, and they ordered that bail can be granted in those cases where a person has undergone 1/2 of the maximum sentence which is prescribed. After this section was added, not many people, not many jailers complied with it. So public interest litigation was filed by Professor Bhim Singh, and directions were also issued in that particular case so as to implement this section 436A. Supreme Court ordered all the jurisdictional magistrates to go to the jails and find out what is the sentence that has been served already by the under trial prisoners, and then make orders under 436A accordingly. That was done all over India. That's Bhim Singh's case is 2015 or 14 case. Have to check with that. That was for implementation of 436A. The rule here is under 436A that accused has the right to be released on bail if he has served a total period calculated of inclusive of investigation, inquiry, and trial. If the total period of detention after crime has been done till the adjudication is greater than half of the maximum sentence prescribed. So let's say there is one offense for which the maximum is, let's say, 10 years. We're not looking at minimum. Minimum is, let's say, 2 years and maximum is 10 years. We have to look at the maximum. So in this case, if he has already served 5 years, then he has a right to be released on bail. However, there is an exception here. Exception here is that public prosecutor can be heard. He can object the prisoner's bail application under 436A, and he has to be heard. And if there are reasons, then it can be in exceptional cases ordered that the under trial prisoner continue to be in jail pending trial. However, not in any case where public prosecutor has been heard and his application has been accepted. However, even in those cases, period of detention cannot exceed the maximum punishment provided by law. So let's say in such case, the maximum was 10 years. Then he cannot make a representation after that 10th year has expired. वो 11 years में उसका punishment convert नहीं हो सकता है. ठीक है? And one more exception is it does not apply to offenses which are punishable with death. So death sentence में आपका trial के लिए जितने भी time लगना है लगेगा, that accused person is not entitled to be released on bail under 436A. वो किसी और section में जा सकता है, कोई problem नहीं है, लेकिन 436A में नहीं आ सकता है. Another problem with respect to 436A that we have had is with respect to those offenses where life imprisonment was prescribed. Now, in many of the decisions, high courts took the view, some high courts took the view कि life imprisonment का मतलब होता है imprisonment for 14 years. So half of 14 years is 7 years. So a person should be accused, should be entitled to be released after he has served 7 years if the trial is pending. Now, this approach of the high courts has now changed after the decision of the Supreme Court in the case of Union of India versus V. Sriharan, wherein Supreme Court has said it is nowhere provided either in IPC or CRPC that life imprisonment means 14 years. Power to commute is something and definition of a particular thing is something else. So life imprisonment means imprisonment for the rest of the life till his last breath. The power to commute is a discretionary power. So you cannot mean it to 14 years imprisonment. Because of this decision now, the high courts have changed their stand. And in the case of Zohra Sheikh versus State and City of Delhi, a Delhi High Court decision. In the case of Deepak Gupta versus State of Odisha, 2019 Odisha High Court decision, both these high courts have held that 436A will not be applicable to an offense where the maximum provided is life imprisonment. Because life imprisonment ka aadha kya hoga? We don't know. So this does not apply even to life imprisonment offenses. Let's see what the Supreme Court says on this. There is no authoritative pronouncement of the Supreme Courts. In fact, there are contrary decisions of the Delhi High Court itself and other high courts. Some high courts have allowed release of people, accused people under 436A when they serve 7 years. But now it will be wrong because of the decision of the Supreme Court in the case of V. Sriharan. I hope I'm clear with that. Yes.